Did people hear the intro that time, by any chance? That was the intro. I don't know what the hell's up. Anyways, regardless, happy Valentine's Day, everybody out there. That was the intro for my musical brother. I've referenced several times, but apparently nobody fucking heard because it didn't show up. I don't understand. It's not copyright. I own it. He made it for me. It's mine. It's ours. Happy Valentine's Day, chat. All right. So today we have conflicts of laws. No more remedies until Friday. So we have right now interest analysis in theory and practice regarding conflicts of law and modern approaches to conflicts of law between states. So we have today the lovely case of Hurtado versus Superior Court. It's a California case from the California Supreme Court from 1974. The opinion we have here is by Justice J. Salomon. In this proceeding, petitioner Manuel C. Hurtado seeks a writ of mandate directing Respondent Superior Court to vacate its ruling that the applicable measure of damages in the underlying action for wrongful death was that prescribed by California law without any maximum limitation, rather than that prescribed by the law of Mexico, which limits the amount of recovery. We have concluded the trial court correctly chose the law of California. We deny the writ. Real parties in interest, the widow of the children of Antonio Hurtado, hereafter plaintiffs, commenced action against Manuel Hurtado and Jack Rexius, I don't know how to say it in Spanish, Rexius, hereafter defendants, the underlying action for damages for wrongful death arising out of an automobile accident occurring in Sacramento County on January 19, 1969. Plaintiff's decedent was riding in an automobile owned and operated by his cousin, defendant Manuel Hurtado. Defendant Hurtado's vehicle, while being driven along a two-lane paved road, collided with a pickup truck owned and operated by defendant Rexius, which was parked partially on the side of the road and partially on the pavement on which defendant Hurtado was driving. Upon impact, the truck in turn collided with an automobile parked in front of it, owned by Rexius and occupied by his son. The decedent died as a result of the collision. At all material times, plaintiffs were and now are residents and domiciliaries of the state of Zacatecas, Mexico. The decedent at the time of accident was also a resident and domiciliary of the same place and was in California temporarily and only as a visitor. All three vehicles in the accident were registered in California. Manuel Hurtado, Jack Rexius, and the latter's sons were all residents of California. Both defendants deny liability. Defendant Hurtado moved respondent court for a special or a separate trial of issue whether the measure of damages was to be applied according to the law of California or the law of Mexico. The motion was granted, and the ensuing trial of this issue at the ensuing trial of this issue, the court took judicial notice of the relevant Mexican law prescribing a maximum limitation on damages for wrongful death. As a result, it was established that the maximum amount recoverable under Mexican law would be 24,334 pesos, or $1,946.72, at the applicable exchange rate of 12 pesos per dollar. After the submission of the issue on the briefs, the trial court announced an intended decision and filed a memorandum opinion ruling in substance that it would apply a measure of damages in accordance with California law and not Mexican law. Defendant Hurtado then sought a writ of mandate in the Court of Appeal to compel the trial court to vacate its ruling and to issue a ruling that Mexico's limitation of damages for wrongful death would be applied. The Court of Appeal granted the alternative writ and thereafter issued a preemptory writ of mandate, so directing the trial court. We granted a hearing in this court upon the petition of the plaintiffs. In a landmark opinion authored by former Chief Justice Traynor for a unanimous court in Rich v. Purcell, a 1967 California Supreme Court case, we renounced the prior rule adhered to by the court for many years that in tort actions the law of the place of the wrong was applicable law in the California form, regardless of the issues before the court. We adopted in its place a rule requiring an analysis of the respective interests of the states involved, governmental interest approach. This objective of which is to determine the law that most appropriately applies to the issue involved. The issue involved in this matter before us is the measure of damages in the underlying action for wrongful death. Two states or governments are implicated. One, California, the place of the wrong, the place of the defendant's domicile and residence, and the form. And two, Mexico, the domicile and residence of both the plaintiffs and their decedent. In the case at bench, California as the forum should apply its own measure of damages for wrongful death, unless Mexico has an interest in having its measure of damages applied. Since, as we have previously explained, Mexico has no interest whatsoever in the application of its limitation damages rule to the instant case, we conclude that the trial court correctly chose California law. To recapitulate, we hold that whereas here in California, an action, both in this state as a forum and a foreign state or country, are potentially concerned in a question of choice of law with respect to an issue in tort, and it appears that the foreign state or country has no interest whatsoever in having its own law applied, California as the forum state should apply California law. Since this was done, we deny the writ. Nevertheless, although our holding disposes of the mandamus proceeding before us, we deem it advisable to consider the argument addressed by defendant in the interest of California in applying its measure of damages for wrongful death. We do this because the argument reflects a serious misreading of Reich, which apparently has not been confined to the parties before us. First, the defendant contends that California has no interest in applying its measures of damages in this case because Reich v. Purcell determined that the interest in the state in the law of governing damages is wrongful death actions is determining the distribution of the proceeds to the beneficiaries, and that interest only extends to local decedents and beneficiaries. Decedent and plaintiffs were residents of Mexico and not local decedents and beneficiaries in California. Therefore, so the argument runs, California has no interest whatever in how plaintiffs or survivors who are residents of Mexico should be compensated for the wrongful death of their decedent. As a result, Mexico, and conversely, Mexico does have an interest. Defendant's reading of Rick is inaccurate. It confuses two completely independent state interests. One, the state interest involved in creating a cause of action for wrongful death so as to provide some recovery for a party, and two, the state interest involved in limiting the amount of that recovery. In Reich, this court carefully separated these two state interests, although it referred to them in the same paragraph. The state interest in creating a cause of action for wrongful death is in determining the distribution of proceeds to the beneficiaries. The state interest in limiting damages is to avoid the imposition of excessive financial burdens on the defendants. In the case at bench, the entire controversy revolves around the choice of an appropriate rule of decision on the issue of the proper measure of damages. There is no contention that the plaintiffs are not entitled under the applicable rules of decision to some recovery for the wrongful death. The Mexican rule is a rule limiting damages. Thus, the interest of Mexico at stake is one aimed at protecting resident defendants in wrongful death actions, as previously explained, and so is inapplicable in this case because defendants are not Mexican residents. Mexico's interest in limiting damages is not concerned with providing compensation for decedent's beneficiaries. It is Mexico's interest in creating wrongful death actions which is concerned with distributing proceeds to the beneficiaries, and that issue has not been raised in the case at bench. The creation of wrongful death actions, insofar as plaintiffs are concerned, is directed towards compensating decedent's beneficiaries. California does not have the interest in applying its wrongful death statute here because plaintiffs are residents of Mexico. However, the creation of a wrongful death action is not concerned solely with the plaintiffs. As to the defendants, the state interest in creating wrongful death actions is to deter conduct that wrongfully kills people. It is manifest that one of our primary purposes of a state in creating a cause of action in the heirs for the wrongful death of the decedent is to deter the kind of conduct within its borders which wrongfully takes the lives of others. It is also abundantly clear that a cause of action for wrongful death without any limitation as to the amount of recoverable damages strengthens the deterrent aspect of the civil sanction. The sting of unlimited recovery more effectively penalizes the culpable defendant and deters it and others similarly situated from future conduct. Therefore, when the defendant is resident of California and the tortious conduct giving rise to the wrongful death action occurs here, California's deterrent policy of full compensation is clearly advanced by the application of its own law. It is important, therefore, to recognize that three distinct aspects of a cause of action for wrongful death: 1, compensation for survivors; 2, deterrence of conduct; 3. Limitation or lack thereof on the damages recoverable. Reich versus Purcell recognizes all three of these aspects are primarily local in character. The first aspect, as far as plaintiffs are concerned, reflects the state's interest in providing for compensation in determining the distribution of proceeds, said interest exceeding only to local decedents and local beneficiaries. The second, insofar as defendants are concerned, reflects a state interest in deterring their conduct. Said interest extending to all persons present within its borders. The third, insofar as defendants are concerned, reflects a state interest in protecting resident defendants from excessive financial burdens. In making a choice of law, these three aspects of wrongful death must be carefully separated. The key steps in the process is delineating the issue to be decided. Defendant's final contention is that California has no interest in extending to out-of-state residents greater rights than those that are afforded by in-state residents, citing Ryan v. Clark Equipment Company. Defendant urges, seemingly as an absolute choice of law principle, that plaintiffs in wrongful death actions are not entitled to recover more than whatever covered in the law of the state they reside in. In effect, defendant argues that the state of plaintiff's residents has an overriding interest in denying their own residents unlimited recovery. Limitations of damages express no state interest. A policy of limiting recovery in a wrongful death action does not reflect a preference that widows and orphans should be denied full recovery. Because Mexico has no interest in applying its limitation of damages in wrongful death actions to non-resident defendants or denying full recovery to resident plaintiffs, the trial court, both as a form as an interested state, correctly looked to its own law. The alternative writ of mandate is discharged and the petition for a preemptory writ is denied. That was the first case. All three of the cases today are from California courts, by the way. So, crazy shit happens with the law in California. Damn. All right. Long case. It's called Bernhard v. Harrah's Club. 1976 case, California Supreme Court. Same Justice, Sullivan again, is presiding. Plaintiff's complaint, containing only one count, alleged in substance the following. Defendant, Harrah's Club, a Nevada corporation, owned and operated gambling establishments in the state of Nevada in which intoxicating liquors were sold, furnished to the public, and given away for consumption on the premises. Defendant advertised for and solicited in California the business of California residents at such establishments, knowing and expecting that many California residents would use the public highways going to and from the defendant's drinking and gambling establishments. On July 24, 1971, Fern and Philip Myers, in response to defendant's advertisements and solicitations, drove from their California residence to defendant's gambling and drinking club in Nevada, where they stayed until the early morning hours of July 25, 1971. During their stay, the Myers were served numerous alcoholic beverages by defendant's employees, progressively reaching a point of intoxication and rendering them incapable of safely driving a car. Nevertheless, the defendant continued to serve and furnish the Myers with more alcoholic beverages. While still in this intoxicated state, the Myers drove their car back to California. Proceeding in a northeasterly direction on Highway 49 near Nevada City, California, the Myers car, driven negligently by a still intoxicated Fern Myers, drifted across the center line and into the lane of oncoming traffic and collided head-on with plaintiff Richard A. Bernhard, a resident of California, who was then driving his motorcycle along said highway. As a result of the collision, plaintiff suffered severe injuries. Defendant's sale and furnishing of alcoholic beverages to the Myers, who were intoxicated to the point of being unable to drive safely, was negligent and was the proximate cause of the plaintiff's injuries in the ensuing automobile accident in California, for which plaintiff had to pay $100,000 in damages. We face a problem in the choice of law governing a tort action. As we have made clear on other occasions, we no longer adhere to the rule that the law of the place of the wrong is applicable in California form unless in the issues before this court. Hurtado versus Superior Court, which we just read, rather we have adopted in its place a rule requiring an analysis of the respective interests of the states involved. the objective of which is to determine the law that most appropriately applies to the issues involved, quoting Hurtado, or Humberto. This issue involved in the case at bench is the civil liability of a defendant tavern keeper to the plaintiff, a third person, for injuries allegedly caused by the former by selling and furnishing alcoholic beverages in Nevada to intoxicated patrons who subsequently injured a plaintiff in California. 2 states are involved. 1, California, the place of the plaintiff's residence and domicile, the place where he was injured, and the forum. And 2, Nevada, the place of the defendant's residence and the place of the wrong. We observe at the start that the laws of the 2 states, California and Nevada, applicable to the issue involved are not identical. California imposes liability on tavern keepers in the state for conduct such as here alleged. In Velesi versus Segarra, this court rejected the contention that civil liability for tavern keepers should be left to future legislative action. First, liability has been denied in cases such as the one before us solely because of the judicially created rule that furnishing of alcoholic beverages is not the proximate cause of injuries resulting from intoxication. As demonstrated supra, this rule is patently unsound and totally inconsistent with the principles of proximate cause established in other areas of negligence law. Second, the legislature has expressed by its intention in the area with the adoption of Evidence Code Section 669 and Business Professions Code Section 25602. It is clear that Business Professions Code Section 25602, making it a misdemeanor to sell to an obviously intoxicated person, is a statute to which this presumption of negligence, Evidence Code 669, applies, and the policy expressed in the statute is to promote safety of the people of California. Nevada, on the other hand, refuses to impose such a liability. In Ham versus Carson City Nugget Incorporated, the court held that it would create neither common law liability nor liability based on a criminal statute banning sale of alcoholic beverages to people who are drunk, because if civil liability is being imposed, it should be accompanied by, or it should be accomplished by legislative action and appropriate surveys, hearings, and investigations to ascertain the need for it and the expected consequences that will follow. It is noteworthy that in Ham, the Nevada court, in relying on the common law rule denying liability, cited our decision in Cole v. Rush, later overruled by us in Velsi, to the extent that it was inconsistent with that decision. Although California and Nevada, the 2 involved states, have different laws governing the issue presented in the case at bench, we encounter a problem in selecting the applicable rule of law, only if both states have an interest in having their respective laws applied. Generally speaking, the forum will apply its own rule of decision unless a party litigant timely invokes a law of a foreign state. In such event, he must demonstrate that the latter rule of decision will further the interest of the foreign state and therefore that it is inappropriate for one of the forum to apply to the case before it. Huerto supra. Say the case they already cited, but nobody discussed. Defendant contends that Nevada has a definite interest in having its rule of decision applied in this case in order to protect the resident tavern keepers, like defendant, from being subject to civil liability, which Nevada has not imposed either by legislative enactment or by decisional case law. It is urged that in Ham Supra, the Supreme Court of Nevada clearly delineated the policy underlying the denial of civil liability of tavern keepers who sell to obviously intoxicated patrons. Quote, those opposed to extending liability point out that to hold otherwise would subject a tavern owner to ruinous exposure every time he poured a drink and will multiply litigations endlessly in a claim-conscious society. Every liquor vendor visited by the patron who became intoxicated would be a likely defendant in subsequent litigation flowing from that patron's wrongful conduct. Judicial restraint is a worthwhile practice when the proposed new doctrine may have implications far beyond the perception of the court asked to declare it. If they urge that if a civil liability is to be imposed, it should be accomplished by legislative act after appropriate surveys, hearings, investigations, we prefer this point of view, says the Nevada court. Accordingly, defendant urges the Nevada rule of decision be the appropriate one for this forum to apply. Plaintiff, on the other hand, points out that California also has an interest in applying its own rule of decision at the case at bench. California imposes on tavern keepers civil liability to third parties injured by persons to whom the tavern keeper had sold alcoholic beverages when they were obviously intoxicated for the purpose of protecting members of the general public from injuries to person and damage to property resulting from excessive use of intoxicating liquor. That's Velsi versus Segarra Supra. California, it is urged, has a special interest in affording that protection to all California residents who are injured in California. Thus, since the case at bench involves a California resident, the plaintiff injured in the state by intoxicated drivers, and a Nevada resident tavern keeper defendant who served alcoholic beverages to them in Nevada, it is clear that each state has an interest in the application of its respective law of liability and non-liability. It goes without saying that these interests conflict. Unlike in Hurtado, the Supreme Court Hurtado versus Superior Court Supra, where we were faced with the false conflicts in the instant case, we were confronted with a true conflicts case. We must therefore determine the appropriate rule of decision in a controversy where each of the states involved has a legitimate but conflicting interest in applying its own law in respect to civil liability for tavern keepers. The search for the proper resolution of a true conflicts case while proceeding with an orthodox parameters of governmental interest analysis has generated much scholarly examination and discussion. The father of the governmental interest approach, Professor Bernhard, originally took this position that in a true conflict situation, the law of the forum state should always be applied. Curie, Second Essay on Conflicts of Law 63. However, upon further reflection, Curie suggested that when under the governmental interest approach, a preliminary analysis reveals an apparent conflict of interest upon the forum's assertion of its own rule of decision, the forum should re-examine its policy to determine if a more restrained interpretation might be more appropriate. To assert a conflict between the interests of the forum and the foreign state is a serious matter. The mere fact that a suggested broad conception of a local interest will conflict with that of a foreign state is a sound reason why the conception should be re-examined, with a view to a more moderate and restrained interpretation of both the policy and the circumstances in which it must be applied to effectuate the forum's legitimate purposes. An analysis of this kind was brilliantly performed by Justice Traynor in Berncat v. Fowler. Curie, from the District of the Third State, his essay. This process of re-examination requires identification of a, quote, real interest as opposed to a hypothetical interest on the part of the forum, and can be approached under principles of comparative impairment. Once this preliminary analysis has identified a true conflict of the governmental interest involved as applied to the parties under the particular circumstances of this case, the comparative impairment approach as to the resolution of such conflict seeks to determine which state's interest would be more impaired if its policy was subordinate to the policy of the state. This analysis proceeds on the principle that true conflicts should be resolved by applying the law of the state whose interests would be most impaired if the law were not applied. Exponents of this process of analyzing emphasize is very different from a weighing process. The court does not, quote, weigh the conflicting governmental interest in the sense of determining which conflicting law manifested the better or worthier social policy on the specific issue. An attempted balancing of conflicting state policies in that sense is difficult to justify the context of a federal system in which constitutional limits, states are empowered to mold their own policies as they wish. The process can accurately be described as accommodation of conflicting state policies as a problem of allocating domains of lawmaking power in multi-state contexts, limitations on the reach of state policies, and distinguishing from evaluating the wisdom of these policies. Emphasis is placed on the appropriate scope of conflicting state policies rather than the quality of those policies. That's from Horowitz, The Law of Choice of Conflict Law in California, UCLA Law Review, 19, doesn't say. UCLA Law Review, 21st volume. However, the true function of this methodology can probably be appreciated only caustically in its application to an endless variety of choice of law problems. Mindful of the above principles governing our choice of law, we proceed to re-examine the California policy underlying the imposition of civil liability upon tavern keepers. As its broadest limits, this policy would afford protection to all persons injured in California by intoxicated persons who have been sold or furnished alcoholic beverages while intoxicated, regardless of whether such beverages were sold, where such beverages were sold and furnished. Such a broad policy would naturally embrace situations where the intoxicated actor had been provided with liquor by out-of-state tavern keepers. Although the state of Nevada does not impose such civil liability on its own tavern keepers, nevertheless, they are subject to criminal penalties under a statute making it unlawful to sell or give intoxicating liquor to any person who is drunk or known to be a habitual drunkard. We need not, and accordingly do not, here determine the outer limits to which California's policy should be extended, for it appears clear to us that it must encompass the defendant who is alleged in this complaint. Advertisees for and otherwise solicit in California the business of California residents as defendant Harrah's Club, Nevada, drinking and gambling establishments, knowing and expecting that said California residents, in response to said advertising and solicitation to use plaintiff's public highway of the state of California in going to and coming from defendant Harrah's Club, Nevada, drinking and gambling establishments. Defendant, by the course of its chosen commercial practice, has put itself in the heart of California's regulatory interest, namely to prevent tavern keepers from selling alcoholic beverages to obviously intoxicated persons who are likely to act in California in their intoxicated state. It seems clear that California cannot be reasonably effectuate its policy if it does not extend its regulation to include the out-of-state tavern keepers, such as the defendant, who regularly and purposely sell beverages to California residents in places and under conditions where it's reasonably certain the residents will return to California and act therein while still in an intoxicated state. California's interests would be significantly impaired if the policy were not applied to a defendant. I think this decision is bullshit. Since the act of selling alcoholic beverages to obviously intoxicated persons is already proscribed, being prohibited in Nevada, the application of California's rule of civil liability would not impose an entirely new duty requiring the ability to distinguish between California residents and other patrons. Rather, the imposition of such liability involves an increase in economic exposure, which, at least for business, would actively solicit extensive California patronage, is a foreseeable and coverable business expense. Moreover, Nevada's interest in protecting its tavern keepers from civil liability of a boundless and unrestricted nature will not be significantly impaired when, as in the instant case, liability is posed only on those tavern keepers who actively solicit California for its business. Therefore, upon re-examining the policy underlying California's rule of decision and giving such policy a more restrained interpretation for the purpose of this case, pursuant to the principles of the law and choice of law discussed above, we conclude that California law has an important and abiding interest in applying its rule of decision to the case at bench. That policy of the state would be more significantly impaired if such a rule were not applied, and that the trial court erred in not applying California law. The defendant argues, however, that even if California law is applied, the demurrer was nonetheless properly sustained because the tavern keeper's duty, as stated in Vesely v. Aguirre, is based on the Business Professions Code 25602, which is a criminal statute and thus without extraterritorial effect. It is quite true, as the defendant argues, that in the Vesely was determined that civil liability, which results when a vendor furnishes alcoholic beverages to a customer in violation of Business and Professions Code 25602, and each of the conditions set forth in Evidence Code Section 669 and Subdivision A is established. It is also clear, as defendant argument points out, that since, unlike California vendor in Vesely, the defendant was a Nevada resident which furnished the alcoholic beverages to Myers in that state, the above California statute had no extraterritorial effect, and that civil liability could not be posited on the defendant's violation of the California criminal law. We recognize, therefore, that we cannot make the same determinations as quoted above with respect to the defendant that we made with respect to the defendant in Vesely. However, our decision in Vesely was much broader than the defendant would have it. There, at the very outset of our opinion, we declared that traditional common law rule denying recovery on the grounds of furnishing alcoholic beverages was not the proximate cause of injuries inflicted on a third person by an intoxicated individual is patently unsound. Observing that until fairly recently it was uniformly held that such an action could not be maintained at common law, and reviewing in detail the common law rule, we concluded that furnishing an alcoholic beverage to an intoxicated person may be a proximate cause of injuries inflicted by that individual on a third person. We reasoned that if such furnishing is a proximate cause, it is so because the consumption, resulting intoxication, and injury-producing conduct are foreseeable intervening causes, or at least injury-producing conduct is one of the hazards which makes such furnishing negligent. But seeing to the question of the tavern keeper's duty in respect to and rejecting his conclusion that the civil liability for tavern keepers should be left to the future legislative action, we noted that, quote, liability has been determined in cases such as the one before us, solely because of the judicially created rule that furnishing of alcoholic beverages is not the proximate cause of injuries resulting from intoxication. As demonstrated, this rule is patently unsound and totally inconsistent with the principles of proximate cause established in other areas of negligence law. Other common law tort rules which were determined to be lacking in validity have been abrogated by this court, and there is no sound reason for retaining the common law rule presented in this case. This decision is such bullshit. In sum, our opinion in Vesely struck down the old common law rule of non-liability constructed on the basis that the consumption, not the sale of alcoholic beverages, was the proximate cause of injuries inflicted by the intoxicated person. Although we chose to impose a liability on the Vesely defendant on the basis of his violating the applicable statute, the clear import of our decision that there was no bar to civil liability under modern negligence law. Certainly, we said nothing in Vesely indicative of an interaction or intention to retain the former rule that an action at common law does not lie. The fact, then, that in the case of bench section 25602 of the Business and Professional Code is not applicable to this defendant in Nevada, such as to warrant the imposition of civil liability on the basis of his violation, does not preclude the recovery on the basis of negligence apart from the statute. Pertinent here is our observation in Rowland v. Christensen, quote, it bears repetition that the basic policy of the state is set forth by the legislature in section 1714 of the Civil Code, that everyone is responsible for an injury caused to another by his want of ordinary care or skill in the management of his property, in quote, in case, fuck California law. Jesus, God almighty. So basically, California law there is saying, right, that like if you go to a bar and get drunk off your ass, and then you drunk drive your car and hit somebody, it's not your fault because you drunk a bunch of booze and drove your car drunk and fucking hit somebody and killed them. It's the person who owns the bar who sold you the alcohol's fault that you drank it, paid for it, consumed it to excess, then decided to drunk drive your car, and were so shitty at doing that you hit somebody and killed them. That's what the California law right here is actually saying. Don't fucking move to California, people. Please. Whatever you do. I wonder how it applies to marijuana law now, too. They can sell weed legally there. So if you sell somebody weed and they're fucking high as hell and they lose their noodles and fucking stab their boyfriend 87 times in the chest, it's the weed dispensary's fault? I mean, it would stand to reason. Speaking of consumption of alcoholic beverages, be right back. All right. Sorry, chat. Who are adults? I'm an adult. Adulting is fun. If who are adults? I mean, all the people at the bars, right, were adults. Like these to be honest, Fern and let me fucking find her name. Fern and Philip Myers actually sound like senior citizens who saw an advertisement on TV to like, hey, go to Harrah's Casino in Elko or in freaking Reno, Nevada. Come drink and gamble with us. And they came and went and drink and gambled, and they were in their twilight years, and they got drunk at the casino. Then they said, well, fuck it, we're gonna drive back home to California anyways tonight. We're not gonna stay at the hotel, which is stupid because Nevada hotels are wicked cheap because they want you to buy booze and gamble there. Like you can get a hotel room in Reno for like $28 a night, like to this day, and it's a nice hotel room. So the bar or the casino and bar sold these people booze. They got drunk, and then they're like, yeah, fuck it, we're gonna drive back to California. We're just gonna do it. And Fern and Philip Myers were driving back to fucking California from Reno, and got really drunk and drove across the median onto the other lane of oncoming traffic and hit a motorcyclist head on. And now under California law, they're trying to sue the people who work, or not the people who work, the casino and gambling establishment, Harrah's in Reno, for serving these people who are not only adults but senior citizens too much alcohol and taking all the agency out of the fucking senior citizens who drunk drove their car instead of staying in the hotel, went across the median into oncoming traffic and head-on freaking nailed the motorcyclist. And California court wants to say, nope, it's actually the fault of the casino in Nevada that sold the senior citizens the alcohol. That seems to be a problem for me in lots of reasons. First of all, because it's bullshit. Second of all, because like personal responsibility and accountability, right? Like if you want, so like, I mean, I know it doesn't work this way because this is civil law, right? But if it was criminal law, like you're like, yeah, officer, I'm drunk as fuck. Don't arrest me. Go arrest that bartender. He sold me all the booze. You know. I mean, it doesn't work in criminal law as much as civil liability, right? But if I'm like, That doesn't make sense. California is particularly cray-cray on this kind of thing. California wants to make all their residents able to collect money from all over the world or whatever for like tort actions and civil liabilities and stuff. And California also doesn't cap damages, so you can get unlimited recovery from any tort action, any harm that was done to you from any other state. So California is kind of trying to, do that. Oh, okay. So we have one final. Any further questions on that, or we're good? One final case, of course, also a fucking California case from 2006, though. See, the liquor store I bought this at is not responsible for my consumption of its alcoholic beverage. I wanted it, I bought it, I'm drinking it. And if I decide to, I don't know, say something heinously bigoted on the stream, which I'm not going to do, I can't be like, well, that fucking liquor store, they made me do it, by God. It doesn't work like that. All right, this is Kearney versus Salmon Smith Barney Incorporated, 2006 California Supreme Court case. So California residents, clients of Salmon Smith Barney, SSB, from here on, is a financial institution, and they brought a putative class action suit against SSB, alleging that SSB recorded conversations between them and SSB brokers in its Atlanta, Georgia office, and that the recording occurred without the client's consent in violation of a California statute. Okay, so California, because like I said, they like to bring in all the money from all the people and just kind of screw the rest of the country over. They're a two-party consent state for recorded calls, which means that if I'm going to call you, like, so if I'm in Florida or Wyoming or Texas or North Carolina or Ohio, single-party consent states means like if I give my consent as one of the parties in a conversation, right, I can call you, and as long as I'm consenting to it, which of course I am because I'm the one recording it, I can record the calls, right? California, a two-party consent state, requires that both parties consent. So if you're in California and you were to call even like one of those freaking 800 numbers or like your customer service, like the following calls may be recorded, blah, 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 right? There's been lawsuits about that because maybe recorded for customer service and quality. No, unless they have your explicit consent to do that, they can't even do that. And so what happened is apparently the people in Atlanta, which is a one-party consent state, were recording calls, but the people making the calls were in California, which is a two-party consent state. So now the people in California are going to try to sue the people in Atlanta to get a fucking ton of money back because they have a habit of recording their calls with their customers. And it's like an investment stock brokerage firm. So like, I don't know, maybe you'd want to have the calls with your clients recorded in case like you're making trades or whatever. Like, fuck, what did they say? They wanted to do what with what stock? And then you might want to check the tape before you start dumping their money into Bitcoin or some shit. So anyways, 1967 statute enacted by California legislature created civil and criminal cause of action against any person or entity that, inter alia, recorded a telephone conversation without the consent, knowledge, or reasonable expectation of recording of all the parties to the conversation, two-party consent. Any person who suffers from unauthorized recording can sue the violator and recover the greater of either $5,000 or 3 times the amount of the actual damage sustained, and can seek to enjoin and restrain any further violations of the statute. California Statute 1509, Section 1, pages 3584 through 3588, enacting California Penal Code Section subsection 66630 tax 637.2. The client sought injunctive relief, damages, and restitution. The Georgia legislature also enacted a privacy statute addressing the recording of telephone conversations, but permits the recording of a conversation so long as one party to the conversation consents to its recording, what I was just talking about. That's fucking a one-party consent state. California says, no, everybody's got to do it. Georgia says, no, one party has to. So basically the one-party consent thing, right? So, okay, so let's say that you're a private investigator and you have tapped my phone because you think I'm running a brothel or I'm talking to Al-Qaeda or whatever, and you're not a government, you're not the government, you're not the cops, you're just a private person who's tapped my phone, right? And now I'm talking to my mom in Wyoming, right? But you're listening in because you tapped my phone. So even in a one-party consent state, the parties to the conversation are me and my mom in Wyoming, right? Georgia and Wyoming is one-party consent states, right? Because you tapped into my phone, right? And you're not one of the parties to the conversation, even in Georgia, a one-party consent state, that would still violate that policy and be civilly actionable and criminally actionable, right? So that's why that distinction still matters. A clear majority of U.S. states permit recording. So basically, everybody more or less permits recording with only a single party consent, except for 11. Well, it says about 11 states, including California, which is not about. I think there's like 8 left now that require two-party consent. It's most like the freaking Northeast, like all those Massachusetts, New England states, and then California. I think even Oregon. I don't. Maybe Oregon. I can check and see. The court concluded that both states have an interest in having their privacy statutes applied to the calls at issue, with California seeking to protect its residents from unauthorized recording and Georgia seeking to protect its residents and businesses from the liability for actions taken in reasonable reliance on the protections of Georgia law. After finding a true conflict between Georgia and California law, the court continued with a comparative judgment analysis. In considering the degrees of impairment of California interests that would result if Georgia law rather than California law was applied, we note initially that the objective of providing individuals in California from the secret recording of confidential communications by or at behest of any other party to the communication was one of the principal purposes underlying the 1967 Invasion of Privacy Enactment. Assembly Speaker Unruh, the principal author of the legislation, prepared a statement that he delivered before the Senate Committee on Judiciary in conjugation and with consideration of the bill, which he explained the impetus for legislation. Quote, in the first place, whereas such invasions of privacy are presented legal only if one party consents to listening, Assembly Bill 860 would require that all parties must consent. This is the most reasonable requirement. Presently, it's entirely legal for one who receives calls to be totally unaware that it's being listened to by another party. Likewise, a party may converse in person with another party who is secretly recording the conversation. He may be fiercely injured by a conversation, another person is liable for his business affairs, and he has no recourse at law. This would cure that defect, a defect that would be less meaningful because the development of law I've passed out to you would indicate is very apparent today. So, again, this all goes back to the same shit. Like, California makes its laws in a certain way, and then the courts of California, which is interpret the law in a way that gives California all the power to interpret foreign laws and state statutes, right? We had the earlier case where California is interpreting a law from Mexico and saying, nah, whatever, Mexico, we don't care about your separate sovereign, like separate national sovereign jurisdiction. We're going to make bartenders in Nevada liable for our dumbass California citizens driving drunk on the roads and hurting our own California citizens. And now we're saying, well, we don't want, but bro, this is a stock brokerage. These phone calls are with your stock brokers. They're recording them for a valid business purpose in Georgia and have notified you of that. But because California law is so sketchy, so grifty, it's fucking putting the courts are like, oh yeah, no, California, we just gotta be, we gotta be safe, man. Whatever, California. Anyways. And even this, okay, so even in a recent California case in 10 years after that was passed in 1978, they found that California statute in question was ancient and rarely, if ever, even utilized, and reliance upon completely had little current interest in the application of that California law. This is a 2006 case, so we're talking fucking literally, I don't math good, 28 years. 28 years later, 28 years before this case, a California court already held that two-party consent thing was an ancient law that had no applicability to current interests of California residents. But no, here comes California Supreme Court clawing that money back, baby. Furthermore, in recent years, California legislature has continued to add provisions to make notifications of the invasion of privacy statute here at issue. So, now it covers cordless phones too. Great. Okay, disclosure of personal information provides a video cassette sales. So it also includes the people who video cassette sales. Okay. In addition, California's explicit constitutional privacy protection was enacted in part to specifically protect Californians from overly intrusive business practices that were seen to pose a significant and increasing threat to personal privacy. Quote, having one's personal conversations secretly recorded may well infringe upon the right of privacy guaranteed by California's Constitution. It was your fucking stockbroker, bro. Like, it's not like some rando called you up and started pumping you for information. He's like, hey, you want to buy medicine from this foreign land, man? I help you out, man. And then, like, you just tell him all your information and he recorded that shit and now he has you. No, it was your stockbroker and you placed the call. Lordy, lordy. Thus, we believe that California must be viewed as having a strong and continuing interest in the full and vigorous application of the provisions of Section 632, prohibiting the recording of telephone conversations without the knowledge and explicit consent of all parties to the conversation. We also believe that the failure to apply this section in the present context would substantially undermine the protection afforded by the statute. Poor California. It would just be so sad. Many companies who do business in California are national or international firms that have headquarters, administrative offices, or, in their view of recent trends toward outsourcing, at least telephone operations located outside of California. If businesses can maintain a regular practice of secretly recording all telephone conversations located outside of California, that practice would represent a significant inroad into the privacy interest that statute was intended to protect. An out-of-the-state company that does business with another state is required, at least in general matter, to comply with the laws of the state of the locality in which it has chosen to do business, as the court determined in Bernhard. Okay, but look, bro. You're dealing with SSB, which is a business that's fucking founded and operates out of Atlanta, Georgia. Your plaintiff here, Kearney, is a California resident doing stockbroking exchange business with a firm in Atlanta, Georgia. So when you say the statute was intended to protect an out-of-state company that does business in another state, is required as a general matter to comply with the laws of the state and locality in which it has chosen to do business. That business chose to do business in Atlanta, Georgia, not in California. Homeboy lives in California, is transacting stock trades with them via telephone in Atlanta, Georgia. So that's a bit of a stretch and a bit of a flip, California court. The court determined in Bernhard, which we just read, in regards to the need to apply California law relating to the liability of tavern owners to the out-of-state tavern owner at the issue in this case, the failure to apply California law in the present context would seriously undermine the objectives and purpose of the statute, which is to get California all the money and fuck over everybody else. Moreover, Section 632, by analogy, another consumer-oriented privacy statute that has been enacted in California would not be applied effectively to out-of-state companies, but only to California companies. The unequal application of the law very well might place local companies at competitive. Yeah, no shit. If you applied your bullshit laws to only California companies, it would place them at a competitive disadvantage. And guess what they would do? They would fucking leave California and go somewhere else where it's easier to do business. So you damn right it would. And that's why you need to keep raking in money from other companies who don't want to do business in California and only have clients and consumers in California. You have to keep trying to snake some of their money away from them because all your fucking companies don't want to corporate in California, don't want to do business in California, and want to get out of there as soon as they fucking can. Lord, exactly. You're right, California, except you're skating. To the extent that out-of-state companies may utilize such undisclosed recordings to further their economic interests, like being a stockbroker, perhaps in selectively disclosing recordings when disclosure serves the company's interest, or by but not by volunteering the recordings' existence or quickly destroying them, then they would be determined to be they would be detrimental to that company. California companies that are required to comply with California law would be disadvantaged. Yeah, because your California law is bullshit. By contrast, the application of Code 632 to all companies in their dealings with California residents would treat each company equally. Yeah, so if you have one single fucking person, if you work in Ann Arbor, Maine, and you run a pet store, and you record all calls because, I don't know, let's say you've had, so let's say you're a pet store that operates out of Maine, out of Bangor, Maine, right? And you sell iguanas and turtle food and dogs, right? And you just got this new employee who's from Bangladesh, learning English very well, right? But not quite there yet, right? but he's a really good employee, and so you're going to leave him to tend the store, right? And so you want to make sure all the calls are recorded for like online, for not online, for phone orders, right? Because sometimes our new employee from Bangladesh doesn't quite understand. So you want to make sure that customer satisfaction is top notch, so you can review the calls and also go over it with him as a training purpose, right? Like, hey, I know that you heard you thought they meant this, but no, actually it was this. Helps them learn English better, helps get into the company policies, helps make sure customer fulfillment is fine, right? If you are unlucky enough to have some dumb son of a bitch from California call you, and you happen to have that video recorded to help your new employee be trained both as an employee and learn the English language, as well as to protect the customer quality of the people who are ordering products from you via phone. Now, all boom, right there. You are now, as far as the California Supreme Court is concerned, under California jurisdiction for violating California privacy laws. Right? I know. That's what they, yeah. I know. Everybody does. So that's, yep. So the conclusion here, in sum, we conclude that the failure to apply California law in the present context will result in a significant impairment of California interests. So, Georgia, California Uber allies. So that's that case, and that brings us to the end of tonight's stream. But yeah, California sucks. I had to live there when I was in the Marine Corps. Not a great time. Not a great time. San Diego's all right. The Gaslamp District, good food, good drinking. Apparently, if you get drunk in the Gaslamp District and just drunk drive your ass into a fucking herd of pedestrians, bar keeps spelt. Not me. Not into it. All right. Well, love y'all. Have a good night. Take care. Happy Valentine's Day. Tip your waitresses. Tip your bartenders. Don't let them serve you too much alcohol. If they serve you too much alcohol, sue their asses into the ground in California. God bless.